Okay, if I may briefly just make a statement. In this current environment of political hostility and instability, that
Yes.
will probably cause a shooting match to start.
Well, not if you're not armed.
Well, if you're not armed, that's correct. Yeah, it probably would cause you to be arrested, though, or asked to leave. And if you refuse to leave, you'll be arrested.
And then that, in turn, gives you the authority under federal law to have every law enforcement officer plus the Board of Elections supervisors to be arrested to face a criminal allegation in a due process hearing on probable cause.
Can I jump in?
I might also point out that if you decide to go unarmed, it probably would not be a bad idea to find all of the high buildings and have some snipers standing by just in case.
That's worst case scenario there, Paul.
Purely as a self-defense measure.
Right. I'd like to jump in. Please allow me a little space here. I love the way you're thinking, Paul, because, Michael, I don't think you have enough background in courtroom warfare that, like Paul and I have got, to know that there is reality under our American and state constitutions to the proposition that for every wrong, the law provides a remedy. That's a common law maxim. And if you follow your pathway far enough, you will have remedy, and that means you will have lawful authority to control the force of the state. I've read in recent conferences how rights are related to authority to control force. And when you've got a right that's being violated, you have authority to control the force of the state or the county. And 2 points, 2 main points in response to your question, Michael. And I forgot them both right now. Maybe not. The county court, okay? You call a session of the county court and you schedule it for the meeting of the county commissioners. Unless, like in Oregon, there's a statute that says that the county court will hold on the first Monday of every month at 10 a.m. And so that's really beautiful. But unless you've got some superpower statute like that, just generally provide a notice that you, as a constituent member of the county, organic body politic under common law jurisdiction, you are calling a session of the county court during the time period when the county commissioners or supervisors meeting is happening. Okay, and you put out the word to all of your supporters to be there, because we're going to take the commissioners. You see, the commissioners have a limited jurisdiction. They've got a municipal jurisdiction, which is an inferior jurisdiction, and the only reason those commissioners or supervisors are in place. The only reason those commissioners or supervisors are in place is because the people are not regularly holding their own county court common law governing body sessions. And so when you call a county court meeting, and they usually have opportunity for comments and questions up front, that you get your 3-minute opportunity to speak there at the start of the meeting, and thereunder, you send them the paperwork up front, and then you move for a position for opening comments for the 3 to 5 minute comment, and you say, I'm invoking the county court common law jurisdiction to try a judicial complaint against, what was there, 30 commissioners there? Maybe try 20 or 25 of them for corruption. Maybe a few of them are halfway decent people, but anyway, you can bring the judicial process right there. You can also summon the sheriff at the same time. You can stack so much on top of it that it never resorts to arms, Michael, is all I'm trying to say. I yield.